ask yourself a question: why some people are really good at what they do and reach consistently great results in comparison to the rest of specialists in their area? Well, I've been absolutely fascinated by this question and spent a lot of time researching it. And what I realized is this: true specialists with special skills and deep knowledge work out the structures, the systems of their trades, and then apply these structures and systems on a consistent basis. This allows them to bring consistently amazing results over and over again. Hello, my dearest friends. My name is Svetlana Shlapak, and I'm a senior immigration solicitor based in London, UK. And I'm also the creator of this free ukvisasuccess.com channel. I won my first immigration case at the tribunal back in 2003, and this gives me over 15 years of experience in UK immigration field. I've created another special video series for you called Deconstructing Immigration Rules, where I've deconstructed over 30 immigration categories for you. I've created this video series with only one aim: to help you understand the structure of immigration rules, because knowing the structure always helps achieve astonishing results. And for those of you who want to see how to apply this structure in practice, you can also check my other video series where I show you how to do exactly that. It is called ukvisasuccess.com frequently asked questions. Okay, let us deconstruct your next immigration category. And yes, my friends, immigration law is a very, very deep area of law. I can only take so much of your time during each video, and as much as I love to, I have to be very succinct and choose the most important parts to explain to you during these videos. If after watching these videos you decide that you would like to know more, please visit ukvisasuccess.com more, as at this page I've provided you with the links to great free in-depth material which will help you on your way to success with your immigration matter. Requirements for indefinite leave to remain in the UK as a partner. There are 5 key elements. The first one is you must be in the UK. The second one, you must have made a valid indefinite leave to remain application. Thirdly, you must prove that you meet all the suitability requirements. Fourthly, that you meet all the eligibility requirements. And finally, at element number 5, I'll explain whether or not there will be any conditions imposed on your stay in the UK after you were granted indefinite leave to remain, and whether or not you can lose your indefinite leave to remain application. The first element: you must be in the UK. This is a pretty straightforward one. You can only make your indefinite leave to remain application when you are in the UK. Secondly, it's all about making a valid application, and as always, it consists of 5 steps. The first one: you must complete the correct form. The correct form is Set M, the online version of the Set M, so you're no longer given any option as to whether or not you should submit the paper version. It's all about making online application. The fee, currently it is £2,389, and if you want to make an application and use their premium service, then you would need to pay an extra £2,999, and you need to pay for your biometrics, and there is no immigration health surcharge to pay unless when you apply for indefinite leave to remain, your application is refused and you are granted further leave to remain. This normally happens when, for example, the applicant is required to meet the English language requirements and they don't, or they do not meet some other eligibility requirements, and the decision maker does not refuse the application, but they give further leave to remain application. The third element of the application is you must meet all the suitability requirements. As with all suitability requirements, there are 2 types. The first one is mandatory grounds for refusal, and the second one is discretionary grounds for refusal. Suitability, I've dedicated a separate video explaining all the suitability requirements, but generally it's about deportations, expulsions, criminal convictions, dishonesty, failure to comply with the Home Office directions, and a failure to disclose material facts or similar activities. If you think that you can be caught by one of the or more suitability requirements, please do watch this video just to be absolutely clear on what these grounds are. If you're caught by mandatory grounds for refusal, then the decision maker has no choice but to refuse your application. If you're caught by the discretionary grounds for refusal, then the decision maker can exercise the discretion in your favor and allow the application. Moving on to the eligibility requirements. First of all, you must have a valid leave to remain in the UK. So you should not be an overstay unless they state here paragraph 39E applies. Let me explain what paragraph 39E is all about. Paragraph 39E normally applies in two circumstances. The first one is when the applicant was late in submitting the application by no more than 14 days. So they give this 14 days period of time, provided with the application or with the late application, they submit evidence proving that they were late because of some circumstances which were outside of their or their representatives' control. And according to their guidance, to the Home Office guidance, they prompt the decision maker to consider the possibility of reasons and to check whether or not the reason was genuinely outside of the applicant's control. And they also ask to consider what evidence were provided to prove that. And they give a couple of examples here. They say that this can be when there was an emergency, a hospital emergency, health-related emergency, or where there was a close family bereavement, or an educational institution was not sufficiently prompt in issuing a confirmation of acceptance for studies. And the second case scenario where paragraph 39 can apply is where an application was made on time and then it was refused, and the applicant applied for appeal or administrative review. It really depends on the circumstances, and that was refused. And after that, they've made another application. So here in this case scenario, they also are allowed to have this 14 days grace period. Second eligibility requirement, they say that if you're following the 5-year route, you should have remained in the UK for at least 60 months with the leave as a partner. And they do say that in their rules that it should be the same partner. And so you're not allowed to switch partners. And if you're here and you're following the 10-year route, this normally happens when a person was unable to meet the eligibility requirements in the past and they were granted further leave to remain and they were switched to the 10-year route. So if this happens, then you would need to prove that you remain in the UK with a valid leave to remain as a partner for at least 120 months, which is 10 years. Third eligibility requirement is you continue meeting the eligibility requirements for remaining here in the UK, and I've explained the eligibility requirements in my previous video when discussing a leave to remain as a partner. Please do watch it if you don't know what the eligibility requirements are all about. And if you're unable to meet the eligibility requirements, all of the eligibility requirements, you need to at least meet the relationship requirements, and then you need to prove that you continue meeting paragraph EX1. There are two possible routes where paragraph EX1 applies. The first one is when there is a child involved, and the second one when you can prove that there is genuine and subsisting relationship between you and the partner. The first route, when there is a child is involved, you need to prove that you have genuine and subsisting parental responsibility with the child who is under the age of 18 and who is either a British citizen or someone who is in the UK continuously and he's been living here for at least 7 years preceding immediately to the date of application, and it would be unreasonable to expect the child to leave the UK. The second route is when and you have a partner who is a British citizen or who is settled in the UK or who is someone with a refugee status or humanitarian protection. And secondly, there are insurmountable obstacles to family life with a partner continuing outside the UK. And here I give you some examples of what insurmountable obstacle can be. Well, normally this means that there will be very significant difficulties which would be faced by the parties to continue their family life together outside the UK, and which could not be overcome or would entail very serious hardship for the applicant and their partner. And normally, when they decide cases like this, they will take the following factors into consideration: ability to lawfully enter and stay in another country, cultural barriers, the impact of mental or physical disability, and the security situation in the country of return. This first route, when there is a child involved, is significantly stronger than the second one because they take really seriously the interest of the children involved when considering any type of application. And finally, you need to demonstrate that you meet the English language requirement. And for indefinite to remain applications, these should be a test at the level of B1, B2, C1, or C2, unless you're exempt or you're from the majority English speaking country, or you have a bachelor degree or a master's degree or PhD, which was taught in the UK or is a NARIC UK recognized institution. And they also add one more requirement here. They say that you should prove that you have sufficient knowledge about life in the UK. So all this means you need to pass life in the UK test. And if your application is successful, there will be no conditions attached to your grant in the UK. So in other words, because before that you were supposed to show that there would be no recourse to public funds, now there is no condition attached to your stay, so you can remain indefinitely without any conditions attached to your stay, and you will be allowed to remain in the UK indefinitely. However, you should remember that if you leave the UK and you are outside for more than 2 years, you are most likely to lose your indefinite leave to remain. And one more thing is there is no need for you to wait for another 12 months before you can apply for your British citizenship. So you can make, after receiving your ILR, you can make your British citizenship application on the grounds of your marriage straight away. And one final thing, if you're a spouse or a partner of a British citizen and you are living abroad and are thinking of joining your spouse in the UK, then you will greatly benefit by checking out my free mind map. This mind map will help you with one crucial thing. It will help you avoid one of the most common mistakes people make when submitting their visa applications to enter the UK as spouses or British citizens or someone who's settled in the UK. This mind map is completely free and you'll find the link in the description.